Hello.
Yes, we can hear you, Chairperson.
Yeah, can you do a roll call, please?
Good morning, Chairperson. Chairperson, as I had indicated earlier that on the platform, we do have the sufficient number of members. In this instance, Chair, we've got Dr. Litchfield Chabalala, we've got Honorable Clark, we've got Honorable Mvana, Honorable Makafane, we've got Honorable Makasi on the platform, Chair. Uh, we are good to start with the meeting, Chairperson. Thank you.
Yes, if you can just share the agenda because it's been long now. Um, we don't have much time for this meeting. We literally have about 2 hours. I hope the team that is going to present is really going to highlight certain things because material have been shared. The assumption is that everyone has read. Can I get a mover and seconder for the agenda?
I move, Chair.
Who's moving? I can't see. I'm using a phone.
Honorable Ramulo, good morning to everyone and yourself, Chair.
Thank you. Honorable Ramulobe. There's a seconder for the meeting, for the agenda. Members,
Chairperson,
yes.
Dr. Litchfield Chabalala Mike's was on, but we couldn't hear from our side. Doc, we couldn't hear you.
Dog. Hello,
Chair,
Doc.
I think Dr. Litchfield Chabalala's mic has a problem, Chair, because her mic is on, but we can't hear her. Perhaps if we can get another member to second the adoption of the agenda.
Please, honorable members. Members, can you please cooperate and so that we can finish our meeting on time? Are people in the meeting or they just logged on and move? What's happening?
Chair, I'm not sure, but there are quite a few names of members that are logged on in the meeting. And Ms. Ramulubeng has moved, and we're just waiting for the second, Chair. Thank you very much.
Members, can we work together, please?
I'm using another device. I hope you can hear me. I second, Chair.
Thank you very much. Agenda has been seconded. Are there any apologies?
Yes, Chairperson, we do have a few apologies. The first one, Chair, would be from Ms. Marina van Zyl. She has an exam today. Ms. Mvana is chairing another meeting, Chair, and Ms. Male Bukobe will join in at 10 o'clock. She's traveling. And then from the department, Chair, we have an apology from the Minister and the Deputy Minister due to prior commitments. However, there are two officials from the department that are attending on their behalf. Thank you very much, Chairperson.
Okay. Thank you very much. We have two presentations. Who's going to be leading us? So my suggestion that we take both and then we comment and then we adopt later.
Yes, Chair. Before we proceed, Chair, Honorable Clark's hand is up.
Yes, Honorable Clark.
I'm sorry, Chairperson. I was switching over devices and I couldn't second the agenda. I did send in an apology that I would have to leave at 10 o'clock because I am writing exams and won't be able to attend the full meeting today. Although I had prepared a written document, which I would also send speak to the department. Okay.
No, that's fine. If you've got comments, please send them to the team that is administering the work of the ad hoc committee. That's okay.
Will do. Thank you, sir.
Thank you very much. Can we please proceed, because we don't have much time with the presentation, please?
Morning, Chairperson. Morning, Chairperson. Am I audible?
Yes, you are audible. Thank you very much. We can proceed.
Sure, Chair. Morning, Chairperson. Morning, honorable members. Following the meeting of, let me just see if I can get this to move. So sorry about that. There we go. So following the meeting of the 24th Chairperson, where members considered the policy framework on the review of Parliamentary Villages Board Amendment Act, a number of questions arose, which constituted legal questions. The Constitutional Legal Services Office has responded to these questions in a legal opinion, and I am made aware that all members have received the said legal opinion. So this presentation is just a very high-level overview of the legal opinion and summarizes the salient features of the said legal opinion. So I will be brief. So what were the key questions? As I mentioned, there were 5 key questions before the committee. The first being, can the board be given the authority to procure services in relation to day-to-day operations of parliamentary villages, considering Section 44 of the FMPLA, the Financial Management of Parliament and Provincial Legislatures Act? Consider whether there are any provisions in the FMPLA that the board and Parliament will need to comply with if Parliament is the custodian of the parliamentary villages in terms of Giyama. What is the role of the STP in relation to custodianship in terms of Giyama? Whether the Joint Standing Committee for the Financial Management of Parliament plays a role in terms of oversight in relation to the board? And what would happen to existing contracts entered between the Department of Public Works and Infrastructure and service providers pertaining to the villages when Parliament assumes custodianship? So those are the 5 questions which our legal opinion dealt with. So in order to understand whether the board can procure, we need to break down the policy context and what happens when Parliament becomes the custodian. So what does Giyama say? Giyama says that a custodian is a caretaker of immovable assets, and this can be found in Section 4.2 of Giyama. The custodian is responsible for the management and for maintaining and reporting on the assets. The Custodian Immovable Asset Management Plan, or the KIAMP, is then submitted to Treasury and forms part of the strat plan of the custodian. The custodian is also liable for any acts of omission related to the asset, as the custodian is responsible for the management of the asset. And what does this mean for Parliament? Well, if designated custodian, Parliament, through its accounting officer, will manage and maintain villages. Parliament will hold the budget for maintenance of operations. The accounting officer will procure services. The FMPLA defines the accounting officer as the STP. And the FMPLA then also provides that the STP is responsible for procurement. This can be found in Regulation 210 of 2015 to the FMPLA. The regulations to the FMPLA provide that the STP implements the supply chain policy and establishes bid committees. Therefore, Parliament would procure the services in terms of the FMPLA via the STP. But can the board procure? So the legal status of the board is as follows. The board is currently established as a juristic person under Section 2.1 of the Parliamentary Villages Management Board Act. It has its own legal personality, distinct from the natural persons who created it. It can legally enter contracts and procure in its own name. However, what is the practical reality of this? The procurement of the maintenance has been done by DPW and not the board. That's what the current status is. The board has no staff, no procurement structure, no track record of using its juristic powers, apart from having a bank account and facilitating payment of transport. The Act does not state who the accounting officer of the board is. Should the board remain a juristic entity, it would be included as an entity under the PFMA, as it will require a budget vote. The board would then need to report under the PFMA and not the FMPLA. If the board is not the custodian, it would not require a budget and would not need to be constituted as a juristic person. Therefore, our recommendation is as follows. Given the committee's policy decision to designate Parliament as the custodian, Parliament will therefore be responsible for maintenance, procurement, hold the relevant budget, and carry out associated duties relating to that budget. It is therefore not recommended that the board be re-established as a juristic person with independent procurement powers in terms of legislation. If the policy decision is, however, to make the board a user, there is no requirement that the user needs to be a juristic person. GIAMA can then be amended to accommodate the board as a user, and the board will require an accounting officer and staff. However, we also recommend that Parliament be the custodian and user, as GIAMA does allow for this. Let's unpack Section 44 of the FMPLA. So what does Section 44 say? An MP is prohibited from being a member of a committee evaluating or approving tenders, quotations, or contracts for Parliament, attending such a committee meeting as an observer, participating in any other way in evaluating or approving procurement for Parliament. What is the intention behind this? The purpose is to preserve separation between MPs approving the budget, which is oversight, and procuring of service, which is administration. This is rooted in Section 217 of the Constitution, in order to make procurement fair, equitable, transparent, competitive, and cost-effective. This prevents political interference in supply chain. We must remember that this is not a barrier, but rather a constitutional safeguard. Does Section 44 then apply to the board? Before the designation of Parliament as custodian, Parliament is defined in the FMPLA to be the National Assembly and the National Council of Provinces. The parliamentary villages and the board fall outside this definition. Therefore, Section 44 does not apply directly to the board. The board has a separate juristic person and is therefore not subject to Section 44. But after Parliament becomes the custodian, Parliament, as custodian, will hold the budget for maintenance of villages. Procurement will be conducted through Parliament's SEM system. Section 44 will apply, and MPs may not participate in or observe procurement processes relating to parliamentary villages. So the board and FMPLA, the second question was dealing with whether there are any provisions that the FMPLA applies to the board. Does the FMPLA apply to Parliament? And should Parliament assume custodian of the parliamentary villages, this will constitute assets under Parliament's responses, requiring full compliance with the FMPLA in respect of planning, budgeting, procurement, and day-to-day operations. The accounting officer is the STP in terms of the FMPLA, as explained, and is responsible for managing, safeguarding, and maintaining Parliament's assets under Section 30 of the FMPLA. In terms of the regulations to the FMPLA, particularly Regulation 6 of the FMPLA, all procurement must comply with Regulation 6. There must be a competitive bidding process as prescribed and the prescribed committee system. This bid committee system can be found in Regulation 7 and requires bid specifications, bid evaluations, and bid adjudication committees for competitive processes. And these are the sections relating to budgeting, procurement, and day-to-day operations in terms of FMPLA, which Parliament will need to comply with. In order to respond to the third question about what is the role of the STP in relation to the custodianship as per GIAMA, we must unpack the roles of custodian versus user. The custodian has an ownership-related management and oversight of immovable assets. It prepares the custodian immovable asset management plan. It submits the custodian immovable asset management plan to the Treasury as part of its strategic plan. It complies with Section 13 of GIAMA, which sets up the roles of the custodian. Parliament, via the STP, will execute these functions in line with the FMPLA, whereas the user has a more operational use of the immovable asset in support of service delivery. It prepares the user immovable asset management plan and must comply with Section 14 of GIAMA, which sets out the role of the user. It requires its own accounting officer and staff if designated separately, and that we've explained if the board is designated separately as a user. The recommendation, therefore, is that Parliament should be designated as a user. The fourth question related to the Joint Standing Committee for Financial Management of Parliament and whether the Joint Standing Committee for Financial Management of Parliament plays a role in terms of oversight of the board. So the first brown block, it considers Section 4 of the FMPLA. Parliament must maintain oversight in terms of financial management, and that's what Section 4 of FMPLA says. Subsequently, then, Joint Rule 146 and 150 established the Joint Standing Committee for Financial Management of Parliament to maintain oversight over Parliament's strategic plan. If we look at the third brown column, Section 13(1)(a) of GIAMA states that the Custodian Immovable Asset Management Plan forms part of the strategic plan. So therefore, if members consider the first white block, there is no direct oversight of the board currently. But the JSC-FMP does not exercise direct oversight of the board itself, as parliamentary villages fall outside the definition of Parliament currently. But if you look at the next column, if Parliament is made custodian, the JSC-FMP oversees Parliament's financial management insofar as it pertains to Parliament's role as the custodian of villages. And also because the KIAM will form part of the strategic plan, and the strategic plan is considered by the JSC-FMP. A political decision, therefore, must be made. If direct oversight of the board functions is required by a committee, this is a political decision and must be provided in the bill. It would also be necessary to indicate who the board reports to. It is recommended that the board, as a non-juristic entity, is required to report to presiding officers of Parliament, and that it must submit plans and reports related to, for example, the procurement needs of parliamentary villages to the accounting officer of Parliament. So the question relating to existing contracts, which is the last question that legal services had to consider, was what would happen to existing contracts and existing contracts with DPW for the villages. The purpose of transitional provisions are threefold. It manages change, guidance on how existing rights, obligations, and procedures will be handled during the transition period. It ensures continuity. It addresses how ongoing contracts and agreements will be treated, specifically that old terms remain until parties adjust. It then finally facilitates implementation. It outlines steps, timelines, stakeholder responsibilities for implementing new laws. Therefore, we suggest that a draft transitional clause can be drafted for the bill and be included in the bill. And the draft clause would read something like this, that all contracts currently in effect between DPW and other parties relating to the villages are deemed to be contracts between the accounting officer and the relevant party and continue in effect until rescinded, revised, or amended. And then we go on to say that either the accounting officer or other contracting parties may propose, negotiate amendments, or cancel the agreement within 2 months' notice within 12 months of the commencement of this act. We then also recommend that perhaps we conduct an audit of all existing contracts, and all current parties should be listed as stakeholders to be consulted during the bill's development. Finally, members, based on our legal opinion, we therefore recommend the following. Parliament will be the caretaker of the parliamentary villages, carrying out all custodian responsibilities under GIAMA and undertaking all related procurement. The STP, as accounting officer, is responsible for all procurement for maintenance at the villages in accordance with the FMPLA. The committee must consider whether it must re-establish the board as a juristic person. Given that the custodian can also be a user under GIAMA, we recommend that Parliament be designated as both. The JSC-FMP will not directly oversee the board, but will oversee Parliament's financial management as custodian, but it is recommended that an accountability line for the board is identified in the bill. And lastly, the bill's transitional provisions will manage the transfer of existing DPW contracts and an audit of all existing contracts is strongly advised. Thank you, members.
No, thank you very much. Members, there are recommendations in each and every instance that is coming from legal. Can we ask for questions for clarity and endorse or refuse the recommendation, taking into account that these are legal questions which were asked by us as members, and we are now have been responded to by the legal section of Parliament, and we just need to make a decision so that the team can proceed with the work. Yes, members, are there any hands?
Chairperson, Ms. Clark, Ms. Mafakane, as hands are up.
In that order, please.
Chairperson, I agree with the recommendations from the legal services. I think that's correct in terms of the PFMA as well. Thank you.
Thank you very much. Member Mahafan.
Good morning, Chairperson. Good morning, honorable members. I also agree with the recommendations, but I just have one question. Are we then not concentrating all powers in the STP while weakening independent oversight if we move with that? And also regarding existing contracts, before Parliament assume custodianship, can the committee then be provided with full audit for every existing DPWI contracts, including contract values, duration, penalties, and service providers there? Thank you very much. That's all.
Member Litchfield.
Thank you. No, I'm covered. I was also concerned about the existing contracts when Parliament takes over to ensure continuity and also to manage change. But I think Mahafane has covered me. So I support the recommendations.
Thank you very much. Are there any other issues, members? Yeah, so that's fine. I think all recommendations understand we don't want to have a void. So the contracts that are there, they'll have to be transferred so you can come back to us. That way. So that we don't get involved, because one of the warning that is coming from this issue is that we don't necessarily have to get involved in supply chain issues, but we can do an oversight over supply chain issues. I think that's the understanding. Any last comment from you so that we can go to the next presentation? Team legal. Hello,
Hi,
colleague.
sorry. Yes, sorry, Chair, you broke up a bit. I will respond once Dr. Clark has completed her presentation, as I think there will be a few overlap questions as she might answer a few of them in her presentation, particularly around the STP's power and the board's function in terms of oversight.
Okay, so let's
Would
move
that be okay?
That's fine. Let's move to the next presentation.
Thank you, Chair.
Good morning, Honorable Chairperson and Honorable members. After the committee has taken the decisions as on the questions that Ms. Hallie Stark has just introduced now, there is two things. There's aspects that will now require a committee decision, given what what the committee has just approved in those recommendations. And then the second part is just to confirm how proposals have been drafted to give effect to certain committee decisions that was taken at the workshop. So the first question that follows directly from the presentation by Legal Services, I can summarize as follows. When the committee said they agreed with the recommendations that were posed in the Legal Services presentation, the committee said decision is then that Parliament will be the custodian as well as the user. Parliament, through its custodian and the accounting officer of the custodian, being the secretary to Parliament, will take all procurement decisions and procurement actions necessary in relation to asset maintenance. And the board will no longer continue as a juristic entity. Okay, so that's the summary of the recommendations as approved by the committee now. Now, there's a tail, members, a loose hanging tail. In terms of the Act currently, the provision of transport services is a function of the board. Okay? It's a function that necessitates the board to have funds. The funds of the board are sourced from two sources. The first one is an annual transfer from the Department of Public Works and Infrastructure and from the service levies of residents. That funds is transferred to the board's bank account. And I've put here what that budgeted and actual DPWI transfers have been for the past year. So what happens to the money? The funds in the board's bank account is used to fulfill payment obligations to service the service provider appointed for transport services. So that's what happens in practice. DPWI does the procurement processes on who the service provider must be, but the board funds pays for those for that transport services contract. The funds of the board is then also used to pay for audit fees, and more recently to pay for consultants to prepare annual financial statements. So now, if the committee has just agreed, the board, or at least understood that procurement decisions, the budget for procurement related to asset management will reside with Parliament as both user and custodian. The question is whether the transport function would then not also more conveniently be located with Parliament, because that will then no longer, if that decision is then taken, there would then be no necessity for the board to have a bank account, and that then also aligns with the committee's decision taken a few seconds ago that the board will not continue as a juristic person. I know the members will probably be thinking now, okay, so what is then left for the board to do? And I deal with that in a few moments when I get to that section. So in light of the decisions taken so far, what would the functions of the board be? The board would still establish rules and regulations applicable to the villages. So members can think of it this way: anything that is not related to asset management. And if we say the decision on the procurement of transport decisions also now lies with Parliament. If it's not related to procurement decisions for transport, if it's not related to asset maintenance, that is where the board will be able to establish rules and regulations on. So the parliamentary villages, for example, the welfare, anything concerning the welfare of residents within the board. The board will then also have an oversight responsibility in terms of transparency and accountability in budgeting and expenditure by Parliament. Parliament will also oversee strategic asset management and maintenance by Parliament. What this will mean is the board will inform the development of the custodian asset management plans and user asset management plan. So in the Act, we can require, in fact, it's strongly recommended that Parliament, as the custodian, be required to consult with the board in the development of the custodian asset management plan and the USIT asset management plan, because we do not want to sit in the current situation where we are now, where decisions get taken in respect of asset management without the due consideration of the board. The board will also have accountability functions. So the committee has also just taken the decision that we understand that the Joint Standing Committee on the Financial Management of Parliament will not have oversight over the board because it's not included in the definition of Parliament. As an oversight mechanism, the board can be required to report to the Executive of Parliament on the execution of its functions. And this functions is not just the asset management members. We should think of it as what is his role in terms of providing suitable and conducive living conditions for members of Parliament and the other categories of persons that resides within the villages. The board also has accountability functions in relation to the Residence Committee. So the board will account to the Residence Committee on matters brought before the board. The board will also make decisions on housing allocation to Parliament, political parties, and DPWI, and they will exercise that through its housing allocation subcommittee that we introduced during the workshop. If members agree that we take care of that dangling function of transport services and that the Act will state that the transport services that will also fall under Parliament, then the board will then also have the function of overseeing the provision of transport services. So just to recap, the functions of the board is establish rules and regulations, oversee transparency and accountability in budgeting and expenditure, oversee strategic asset management and maintenance by Parliament, inform the development of custodian asset management plans, be accountable to the Executive Authority of Parliament and to the Residence Committee, make decisions on housing allocations, and oversee the provision of transport services. So remember that the picture should look like this. The board executes its functions and reports to Parliament on the execution of those functions. The Secretary to Parliament, as the accounting officer of the custodian, reports by virtue of being on the board to the board on that function, but also reports to the Executive Authority of Parliament as the funding for that, the roles and responsibilities related to the custodian will lie, the budget for that will lie with Parliament. So those are the proposals coming directly from the presentation by legal services. Now, as a completely separate issue, members, there were decisions that were taken at the workshop that we had to come back to formulate proposals for. The first one is the composition of the board. Members will recall there was a very strong input from members on what the composition should be like. The decision was the board must have greater representation of persons residing in the villages and those directly affected by the decisions of the board. So this is what the proposed composition looks like, noting that it has expanded from 13 members to 18 members. When we get to the voting rights, there'll be a better understanding of what that might mean. So the members of the board is the chairperson, the house chairperson in the NA responsible for villages, the house chairperson in the NCOP responsible for villages, the chairperson of the residence committee for each village, those 3 residents, which members during the workshop said, I must bring them back, please. The 3 residents, of whom 2 shall be parliamentarians, and 1 shall be a sessional official or designated staff member from the village. The Secretary to Parliament, and I'm putting there, he's the accounting officer of the custodian. He would then advise the board on issues related to that. A nominated representative from the DPWI being the owner of the buildings for all the villages, but also being a landowner in 2 of the villages. A nominated representative from the owner of the land on which 1 or more of the villages are located, where the DPWI is not the landowner. I will elaborate on that in the very next slide, members. and then a member of the South African Police Services. So if I just need to stand still on the issue of representation of landowners on the board, members will recall at the workshop, DPI was asked to confirm land ownership of the properties of the land that the parliamentary villages are located. Subsequent to the workshop, we were informed that Acacia Park and Pelican Park belongs to Department of Public Works and Infrastructure as the landowner. Laboria Park, City of Cape Town is the landowner. So why is land ownership important? The custodial powers that the executive authority of Parliament has could in some way be limited by the fact that Parliament does not own the land. So Parliament might not be able to exercise the full range of management, planning, and disposal powers contemplated in GIAMA. So, for example, major developments, material alterations, and significant upgrades to the immovable assets, the actual buildings. Even as a custodian, Parliament might not be able to do that. So it's prudent to have landowners sit on the board, not necessarily have voting rights, and I'll speak to that in the next slide. So it is recommended that Parliament, parallel to the work of the ad hoc committee,
Sorry, we are missing you now.
Yeah.
engage with DPWI and the City of Cape Town on any limitations.
Dr.
Yes,
Clark,
Yes?
there was a time, like your last slide, if you can start from there because you were mute, like we couldn't hear you, we missed you.
Okay, so the representation of landowners.
Yes.
This one. Okay, perfect. So in the composition for the board, it makes provision for a nominated representative from the landowners. Yeah? Although voting rights will only be given, the recommendation is voting rights will only be given to the House chairperson in the National Assembly, the House chairperson in the NCOP, the chair of the Residence Committee, and the 3 residents. Those will be the only voting right members. The remaining members will be there to advise the committee, the board, pardon me. So, as I said, the proposed board makes provision for representation from landowners. And so we ask the question, why is land ownership important? The powers that the executive authority of Parliament has as a custodian could be limited because of the fact that the land on which the parliamentary villages are built belongs to another landowner. Right? So at the workshop, DPWI was requested to confirm the land ownership for the land on which all 3 of the parliamentary villages were built. Subsequent to the workshop, it was confirmed that DPWI is the landowner for Acacia Park and Pelican Park, and Laboria Park for Laboria Park, the City of Cape Town is the landowner. So there might be limitations that those landowners by law can impose on Parliament because Parliament is not the landowner. So, for example, there could be limitations in terms of redevelopment, material alterations, and significant upgrades that Parliament would not be able to do. So, for that reason, it's recommended that Parliament, parallel to the work of the ad hoc committee, engage with DPWI and City of Cape Town on any limitations that will be imposed on Parliament as a custodian. And that will feed into the public consultation process for the draft bill. Oh, the issue of voting rights. So the persons who is directly affected by the decisions of the board will get voting rights. Who will not get voting rights? The Secretary to Parliament, the nominated representative from DPWI, the nominated representative from the owner of the land, and then the member of South African Police Services who will sit on the board to advise the board. We understand that the landowners, because of the limitations that can be placed, can have considerable input on the decisions that the board may make, but they do not need a voting right to stop Parliament or the board from interfering with their legal rights as owner. They don't need a voting right to stop those decisions. They already, by operation of law, have that right. So that's why it's not necessary for them in the Act to be assigned any voting right to stop decisions that might negatively affect their rights as landowners. Okay, so we've dealt with the issue of why is land ownership important. The second issue is the residence committee. We said who should sit on the residence committee, just to effect the decisions of the members. It would be the House chairperson in the National Assembly. Let me see. Oh, sorry, that's the voting rights issue. And the to have a voting, casting vote in the event of voting rights. Apology. The next issue is the composition and voting rights of the residence committee. Again, in line with the decision of the committee, that residents who are directly affected by the decision of the residence committee and who live in the villages, that they should be the ones taking the decisions of the residence committee. So we will have 3 MPs residing in the village. Proposal: 1 designated support staff residing in the villages, and 1 sessional official residing in the villages. So those will be the voting members on the residence committee. To advise the residence committee, we will have an official appointed by Parliament to manage the day-to-day administration and day-to-day operations in the villages. 1 representative from the facilities management company where 1 has been appointed. 1 representative from DPWI, still being the owner of the buildings, and 1 representative from SAPS. So it is only the first 3 type of member that will have voting rights. The rest of the persons on the residence committee is there to ensure swift responses to any issues that might be raised by the residence committee. You don't want the residence committee to sit with a challenge and after the meeting I have to say, okay, we need to now call Parliament to figure this out as a custodian, or we need to liaise with DPI on particular issues. You want the residence committee to be as responsive as possible. Now, the next question was that we should provide a bit more detail on the Housing Allocation Subcommittee. And I'll start this by reminding members that the Housing Allocations Subcommittee is a subcommittee of the board. Okay? So we also do not want to be so prescriptive that the board actually cannot set rules and procedures for its own subcommittee. So here the proposed composition is MPs, representatives of political parties represented in Parliament that have a member or members residing in the villages in substantially the same proportion in which they are represented in the National Assembly. Now, members will see there's a lot of moving parts. So, for example, for 1 month, there might be a member from the MK that resides in the villages. The next month, that member may no longer need accommodation within the villages, which means that representation on the Housing Allocation Subcommittee would then not be necessary. So for those reasons, the recommendation is the board must make rules. It is their subcommittee. The board must make rules on meeting procedures and voting rights for its subcommittee. The subcommittee will, from amongst its own members, elect a chairperson and political parties. So the board, the members of the sub-allocations housing committee will not be appointed by the board. The political parties will indicate which members will serve on the subcommittee to allow that flexibility in how occupancy within the parliamentary villages might change. Thank you, honourable members. So that concludes the presentation that responds to the workshop. Thank you, Honourable Chair. If there's questions or input now, might I suggest that we deal with them now so that when we get to the policy review report, I will then be able to just draw members' attention to where the new additions are, and then indicate that the policy review report will now be amended with the decisions that the committee has just taken this morning, Chair. Thank you very much, Honourable Chair and members.
Thank you very much, colleagues, for these presentations, and then we are making great progress. Can I now see the hands for clarity and also to make sure that we can concur and make decisions as ad hoc committee? I am not seeing any hands. Members, are you there? Okay. I see Dr. Litchfield.
Thank you, Chair. I think the presentation is clear for me. I am just still digesting the part that deals with the subcommittee of the villages. But I think by and large, they have done what we have asked for. I love the part where they are not too prescriptive on the subcommittee of the villages, because it does allow the board some form of powers. But I'm still digesting that part. Maybe I'll come back with a question. Thank you, Chair.
Honorable Clark will be followed by Honorable Ramulobe. Honorable Clark.
Thank you, Chairperson. I thought you said I would be followed by the honourable member, but these are the following questions I would like to ask, and just to get some clarity as well. Firstly, if there is a quorum threshold of voting and non-voting members, as historically that has hampered the previous board, that is something I just want clarity on, because also the 1-year election for the 3 reps per resident committee could go against the idea of synchronizing residents committee in terms of the office of those of Parliament. And also, how would the DPWI previously that has interacted with the city of Cape Town on the said land ownership of Laboria, and perhaps asking them to send us a report stating the experience with recruitment. This has been a real issue, and it would be good to get that report from the city of Cape Town. And then also, if I can just ask, what acts of legislation and provisions govern the power of landowners, as it also relates to the custodians? And obviously, I also like the idea that each political party would be responsible, in terms of their residents, because we have a housing whip, which is myself, and I deal with all those things on behalf of our party. Thank you very much.
Honorable Ramulobe.
Thanks, Chair, and good morning to colleagues on the virtual platform and the officials. Chair, I think in the last meeting we had at the Good Hope Center chamber, I meant, when we had a meeting, there was an issue that came up, and if I remember correctly, Honorable Kobe would have raised it, and I would have spoken to it, and even Honorable Ntlangwini, on the board composition and the voting rights, and where it makes an indication that it would be 3 MPs residing in the village, and that is inclusive of the chair and the 2 members, so the 3 still being kept as it is. 1 designated support staff residing in the village, 1 sessional official, if they can clarify this too, which is which, because of this both are officials, because of sessional officials are officials coming from departments, who departments have requested them to stay, to be accommodated in villages because of their support political offices or the DG's office. And then designated support staff. Which support staff is this? Is it Parliament support staff, or is it still DPWI support staff? And if it's Parliament support staff, we do have the accounting officer who is sitting. Are we not contradicting that? Are we not having contradiction of the delegation of people that are sitting in the board? Are we not expanding the board with the very same cycle of people? Because of it makes sense. We're polluting it with people who, those who they report to are still sitting and accounting in the board. Because if you have the STP sitting with whoever he will be bringing from his office and there would be someone who's appointed by Parliament to manage the day-to-day operations of the villages, that person would be accountable immediately after the board has taken decision to talk to his or her colleagues or counterparts in the villages on decisions that the board has taken in terms of implementation. So I would require a clarity on the two, Chair, so that we adopt something that it's clear in this instance. And I think I would raise something similar to Honorable Clark on Liberia Park. Since DPW would not have ownership of Liberia is the city of Cape Town, why do we still have DPW sitting there? Because by virtue of us now falling under Parliament and DPW has limited limitations on maintenance and operations of villages, it means in Liberia Park they will have none whatsoever. Then City of Cape Town should be the one as the landlord to come in and sit in matters that relates to Liberia, since they are the landowners to it, Chair. That is my second part. The last one, it would be the STP powers. I would hate a situation, Chair, where we give the Secretary to Parliament absolute powers and we find ourselves in a similar situation that we are in today. We had a board, if we still do, that is supposed to be efficient, existing, but it's not, because based on the current acts and how it has been done, the DG would not be able to convene in an extent. I understand why the board has not been effective in the past years. I have been saying perhaps members that have been appointed to sit in boards have been lazy, but now I understand that no, they were not. It's certain elements that would have prevented them to executing duties that have been bestowed upon them by members of Parliament when they were elected in parks. That's one. I'm happy that based on the last presentation we got at the Good Hope Chamber, where it was making an indication that the STP must be chair, it has been revised that the board will, in its first meeting, elect its own chairperson. And the STP should sit as an accounting officer to the board with no voting powers or voting rights to it. On transport user, Chair, I understand that moving from public works to Parliament, that transition will then entirely mean Parliament must equally oversee the transport thing. I disagree, Chair. I think the same status quo of transport being a sole custodian of the board should still be in that instance. The administrational part or process of it, yes, should be overseen by Parliament or the accounting officer. But when that process gets to be done, the finalization of appointment would be a recommendation that gets to be done by the board, because that's a functionary of the board to ensure that members in between travel of Cape Town, of villages to Parliament, they are being taken care of. Because I would hate a situation that we find ourselves in even today, where board is inefficient, it's not sitting, and that composition gets to be taken by Public Works, and it does as it pleases with it, even when there is a board in existence, but they still continue to carry doing duties of transport allocation appointments when that composition lies with the board. So in essence, I'm saying, Chair, the recruitment process, the advert and everything would be brought to the board to agree, but the administration part would be done by the administration as led by the STP. Then the finalization on the timelines and everything will be presented to the board. The ones that process has been done on the administration part, they would bring to say these are recommended companies or bus companies and so forth, and the board will exercise its duties on who should be considered, and basing that also of doing a thorough local inspection of those bus companies, because some of those buses that are being brought to members for traveling, they leave much to be desired with, Chair. But I still believe that aspect should lie with the board in making sure that whoever gets appointed, the board would have satisfied themselves through local inspection that it's buses that are desired for transportation of members, Chair. But outside everything that has been raised, I agree. Only on those 4 components I would like responses and I'm basing them on the discussion we had at the Good Hope Chamber, Chair. Thank you.
Thank you very much. Those will be questions for clarity. Let me just remind members that is there not, Member Litchfield, have you spoken?
Yes, I spoke, but I did say I'm still digesting, so I have a question, sir.
Okay, you can proceed with your question.
Thank you, Chairperson. Chair, I wasn't in the workshop, so I'm coming at a back foot, even if I read the presentation. I'm trying to understand the rationale of having 3 MPs in the village subcommittee. 3 MPs versus 1, 2, 3, 4, 5 other members. About 6 other members who outweigh the number of MPs. The villages are primarily for MPs and they constitute the largest number of residents. I don't know what the rationale was because it's only 3 MPs against 6 other members in that committee. That would be my clarity. And then also extending on that is 3 MPs against how many parties? I know we are not doing this at party level, but we know even now the dissatisfaction in terms of these villages does go around parties, that smaller parties feel that they're not allocated the best houses and. So I'm wondering why we agreed on 3 MPs. What did we do? How did we calculate that number? Thank you, Chair.
Thank you very much. Let me just remind members with the questions that the clarification was made and the decision has been made with regard to procurement and the role that MPs should play. So let's take that into account. But let me allow the officials to answer the questions so that we can then proceed. Over to you.
Chairperson, just a point of order, please.
Yes.
Exactly what you've just said now. The transport provider appointment is a procurement process. And in terms of the FMMPLA, Section 44 forbids any MP to participate in any decision making of this process. So no, members cannot sit on the board if they decide as such.
Well, let's allow the questions. That's why I'm raising the issue. Let's allow the members to proceed, and then we will then conclude on the issue. Yes, over to you.
Thank you, Honorable Chairperson. So I'm hoping it's okay if I group together the different questions the members had about the composition of the board, representation, and the voting rights. Okay, so if we start with the board, we had said the voting rights for the board will be given to the House Chairperson in the National Assembly responsible for the villages, the House Chairperson in the National Council of Provinces responsible for villages, the Chairperson of the Residence Committee for each village, and the 3 residents. So those are the only members of the board who have voting rights. The rest of the members of the board is to the Secretary to Parliament as accounting officer of the custodian sits on the board so that he can report to the board on the execution of his function as the custodian, as the accounting officer of the custodian and the user. If we now confirm the decision on transport services, the Secretary to Parliament will also then, as a member of the board, report to the board on the provision of transport services. DPWI is there to advise the board as it remains the owner of the buildings in all 3 parliamentary villages and is in addition the landowner of 2 parliamentary for the land on which 2 parliamentary villages are located. A member of South African Police Service is there to advise the board and report on the execution of the safety and security governance arrangements in respect of the board. So only the residents of the board, only the residents of the villages, as well as the political leadership is directly responsible for the proper functioning of the villages. Those are the members of the board who will have voting rights. Everyone else there is in the advisory committee, except for the Secretary to Parliament, who's also there to report to the board on the execution of his function as an accounting officer of the custodian, the user, and if the decision on transport services is confirmed, the provision of transfer services as well. Because remember, the board will inform the custodian asset management plan and the user asset management plan. So they will ask the secretary, this is what the UM says, report to us on the extent to which asset maintenance has followed the undertakings and the commitments that have been made in the UAMP and the CM. It might then become convenient to also talk then about the voting rights of the residence committees. So at the bottom, we say that the members listed in 1 through 3 are to have voting rights. So that's 3 residents residing in the village, 1 designated support staff residing in the village, and 1 sessional official residing to the villages. The remaining of the members are there not to have voting rights, but to advise the residence committee on the implications that the residence committee might have for the day-to-day operations and the administration of the villages, and also to advise the residence committee on responses to any issues that the residents might raise. So the question was why designated support staff and a sessional official. So members will recall that one of the definitions that was already agreed to at the workshop is that a designated support staff is someone who has been appointed by a political party to support the political party, someone who's been appointed by Parliament to support presiding officers, or aides to members with disabilities. Right? So we can think of them, in Afrikaans we say huiskinders. It's Parliament support officials, those 3. The sessional official is an official that's staying there because he's been designated as a sessional official by the Department of Public Works and Infrastructure. The motivation is there might be differences in the needs that a sessional official as a DPI official has versus the designated support staff who are directly linked to Parliament has. So, for example, the designated support staff, they might align their work to Parliament, right? To the parliamentary framework. They might say, okay, we are in recess in June. We are completely happy if all major construction happens in June within the villages. But then the sessional officials will say, okay, no, actually, June is a particularly busy period for us in in the departments, it would be very inconvenient for us if major construction happens in June. So there might be differences between department officials and Parliament support staff in terms of the needs they might have as residents. So that's why the suggestion is allow representation for the DPWI officials there, not as oversight, but as residents living within the villages. The same with the representatives from DPWI in Roman numeral VI. Those officials from DPWI, they are there to advise the committee. So, for example, we know that there's an issue of the sewage in Acacia Park. Yeah? To resolve that issue of sewage, you need input from the landowner. You need input from the owner of the building, and you would need input from the residents. Now, it would be expedient to have all of those persons represented when major decisions on sewage, repairing the sewage line, for example, is taken on the board, as well as when you're talking about timelines for when sewage, when the actual construction on the sewage line is going to be completed, it would be expedient to have both your landowner plus the owner of the building present at the residence committee when those updates are being provided. So that is the motivation for the representation, the voting rights, and why the recommendation is to differentiate between designated support staff, who are Parliament support staff, and sessional officials who are DPI officials who might have different needs as residents. Okay, the next question, there was a question on the quorum, the thresholds for quorum requirements. That will be part of the specifications that is built into the draft bill, but again, based on governance, good practice in governance and voting rights on boards. Because I think what comes out from members was just what members were just saying. We must also remember that the board and the subcommittee is not committees of Parliament. So the normal quorum and thresholds for voting rights, for example, doesn't apply. So it is correct that is something that would have to be crystallized in the draft bill. The question of transport, and Honourable Clerk has also started to respond along the same lines as I would have wanted. So the question is essentially, what decision making can the board have in respect of the provision of transport services? The board cannot take decisions on the procurement of service providers. In fact, they cannot even inform who the preferred candidates would be for appointment as transport services advisors because of what Section 44 of FAMPLA says. So if we say no, the board cannot take procurement decisions, what can it do? It can execute oversight, but we have to be careful here. The oversight will kick in after a procurement decision has been made. And then the board will be able to execute oversight. So we would be able to say who was all of the contractors, what was the technical specifications, what did you guys take into consideration? A month after the contract has started, are you guys doing contract management? The board could then even say, look, we've had a very bad experience with this service provider so far. We recommend that they not be considered again for future contracts for the following reasons. So it's definitely a stakeholder. It is definitely the body that will exercise oversight over the provision of the transport services. But we want the Act to be absolutely clear on where the decision making on the procurement happens. And my worry is if we phrase it too broadly by saying the provision of transport services, in drafting and legislative practice, one tries to avoid that so that the decision maker who's responsible for the function has absolute crystal clarity on what their responsibilities and obligations are. And so for that reason, the recommendation is saying that the board has an oversight function over the provision of transport service versus the board has decision-making in respect of the provision of transport services. We think it's a more prudent wording for the bill. Yes, we agree that it's necessary to get down to the detail of the existing contracts, penalties, durations. And so for that reason, when we get to the Policy Bureau report, members will see that there's a recommendation that Parliament, together with DPWI as legal services has suggested, sits down and does an audit of all the existing contracts. And that will include contract terms, rights and responsibilities, rights and duties of the different parties, for example. So that will run parallel to the work of the committee, and that will serve as input during the public consultation phase of the draft bill. Yes, I think I've covered them all, Chair. If I can find an ask indication if there's anything that I've not adequately responded to. Let me maybe just conclude with this, Chairperson. So this is the picture we should have for ourselves. The Secretary to Parliament is the custodian of the Secretary is the custodian of the sorry, no. The Secretary is the counting officer of the custodian. Parliament is the custodian of the villages. So the Secretary to Parliament reports in two directions. Actually, in three directions, remember. The Secretary to Parliament reports and is accountable in three directions. The first direction is to the board in terms of his functions as a custodian and an asset and a user. He reports to the Joint Standing Committee on the Financial Management of Parliament as the counting authority of Parliament, who has received a budget to look after the asset management within the villages. The Secretary of Parliament also reports to the executive authority of Parliament, who is the custodian. Right? Who does the board report to? We are saying the board will report to its residence committee on issues that has been brought to the board's attention. The board will report to the executive authority of Parliament on the execution of its function. So if you look at it holistically, we can say that there is sufficient transparency and accountability lines to ensure that both the board and the Secretary to Parliament would report on the execution of their functions. I'm hoping that the last summary, Chairperson, paints a picture for members of where the Secretary to Parliament's accounting line would lie. It would definitely not be in the other direction where the board reports to the Secretary. Thank you, honourable members.
Thank you. Just out of your presentation, can you just take us through the decision that must be made so that members are clear?
Let's go to your other thing now.
Excuse me, Chair.
Yes, Honourable Member Litchfield.
I'm sorry to take you back. As I said, I wasn't in the workshop. I am still wondering, why are there 3 MPs in the residence committee against 6 other members in that committee? It's not clear to me.
Yeah, that question was clarified. I think there's more MPs than that. Remember that the chairpersons are MPs. That's the first layer, and secondly, and then they're coming from the 3 villages. But secondly, then the 3 that you see there is just to ensure that there is proper representation. It takes it to about 6, but the team will clarify. That's why I want them to take us through decisions one by one, so that we don't go back to the workshop. But the numbers are fine. Can you take us through the decisions that must be made so that we move one by one?
Just see. Yes, thank you, Honorable Chairperson. So if I could start with the presentation by, let me just ask Talana if I can start with
Yes.
it. Okay, so I'll start with the decisions. It's not going to be on the slide, members. It's going to be just a summary of the decisions. So the first decision was should, yeah. Okay, in fact, I can actually share that slide. Okay. So I will present a summary of the decisions that the committee has taken. On the first question of, sorry. What? There we go. Sorry, Chair, we're struggling with connectivity.
Yes, I can
So
see.
the first question was, the first question was, can the board procure? And the response was because of Section 44 of AMPLA, the board cannot take those decisions. Right? So then it was confirming that Parliament will be the caretaker of the villages and it will carry out all the custodian responsibilities under GIAMA and undertaking all relevant procurement. For that, in the same vein, the decision was that Parliament and not the board will be the user in terms of GIAMA. So we can say that's the first one. Parliament will be both a custodian as well as the user in terms of GIAMA. The second question was, given how the board has operated in practice since its establishment, should the board be re-established as a juristic person? And the committee decision in this respect was no. Because Parliament will take all the procurement decisions necessary related to the asset management and maintenance within the villages, because it would be the custodian and the user. Okay. The fourth decision was the Joint Standing Committee on the Financial Management of Parliament exercises oversight over Parliament. However, the board is not included in the definition of Parliament. So now the question was, who will oversee the board in the execution of its function? The options was it can report to a committee within Parliament, but then a political decision is necessary on what that committee will be. Or we can say the board will report directly to the executive authority on the execution of its function, and members elected for the second option. Then there was a question of how do we deal with transitional provisions? And the response was it will be dealt with through transitional provisions in the bill. And to enable the committee to do that, an audit will be undertaken of all the existing contracts as well as the provisions within those contracts. So that was emanating from the legal presentation. The further decisions that was taken then relates to the need to effect the decisions of the committee made at the workshop. The first and most significant of that was, if the board is not going to be a juristic person, if it is understood that procurement decisions in related to asset management and maintenance will be taken by board, is there a valid reason for why the board must continue to provide transport services? And we said The difficulty faced by the board is it cannot take decisions in respect of the procurement of services because of what Section 44 of AMPLA says, and that the board should rather than see its role as providing oversight over the provision of transport services. We then also said, okay, so in light of the decisions that the committee has taken, what is the remaining functions of the board? It would be to establish rules and regulations, oversee transparency and accountability in budget and expenditure by Parliament, oversee strategic asset management and maintenance by Parliament, inform the development of custodian asset management plans and user asset management plans, be accountable to the executive authority of Parliament on the execution of its function, and be accountable to the Residence Committee on matters brought before the board. It will also make decision on housing allocation to Parliament through its sub-allocations, Housing Allocation Subcommittee, and will oversee the provision of transport services. The composition of the board will extend from 13 to 18 as presented and discussed, and only the House Chairperson in the NA, the House Chairperson in the NCLP, the Chairperson of the Residence Committee, and the 3 residents from the villages will have voting rights. The board will, from amongst its own members, elect the chair, and the chairperson will have casting vote in the event of equality of ties. That's the voting rights. The Residence Committee, 3 MPs residing in the village, 1 designated support staff being the Parliament support staff, and 1 session official being a TPWI staff member, with only the first 3 of the Residence Committee member types having voting rights. For both the board and for the Residence Committee, everyone else serving on the board is there to advise the committee and the Residence Committee on any decisions. The Secretary to Parliament is serving on the board to report to the board on its functions as the executive authority, as the accounting officer of the custodian, the user, and in respect of the provision of transport services. The Housing Allocation Subcommittee, we reminded ourselves that this is a subcommittee of the board. The Act should empower the board to make regulations on meeting procedures and voting rights for the subcommittee, who will from amongst themselves elect a chairperson, and the political parties will indicate the party members. The only thing the Act will say about composition is that the representation must be substantially in the same proportion in which they are represented in the National Assembly. Only the MPs will have voting rights. No, sorry, we leave that up to the board. Apologies, members. Hence saying the board to make rules on meeting procedures and voting rights for the subcommittee. Thank you, Honourable Chairperson. That is a summary of the decisions that the committee has taken.
Can we get the mover and seconder for the resolution so that they are effective, members? And I think clarity have been provided. I am not seeing any hands, honorable members.
Chair, I move.
Thank you very much. Member Ramulbeng moves. Can we get a seconder?
Chair.
Yes, Member Mahafan.
I second, Chair.
Thank you very much. The resolutions have been seconded. Can we move to the next item on the agenda?
Thank you, Honourable Chairperson. The next part is the adoption of the policy review report. Chair, in your introduction, you said we're going to be focusing on the additions. So the document should look very familiar to committee members. It was essentially the document that formed the basis of the discussion document for the workshop. So what I've done is I have in yellow highlighted where between myself and legal services, we have effected the changes that the members have requested. And if all goes well and we adopt the report, we will then adopt the report with the amendment of the inclusion of the decisions that the committee had. That means we then won't need to come back again, Chair, to look at this report. On the strength of the report that was adopted, legal services will then start with the development of the draft committee bill. So the first concern that was raised is in relation to giving the executive authority to Parliament discretion in allowing any other category of person to live within the villages. And there was a concern that creates a risk and it gives the executive authority too much discretion. So to respond to that, it is said that a provision could be included in the bill that empowers the executive authority to determine any other category of person that may lawfully reside in the villages, having followed the prescribed process for making such a determination. So that essentially says, before the executive authority can take any decision on any other category of person, regulations must first be issued by the executive authority, and those regulations must be followed before that determination is made. We also make a recommendation that says that regulations could include, for example, requiring the executive authority to issue a notice to all political parties saying, in addition to the categories of person listed in the Act, Anneke Clark will also be staying in the villages for a particular period of time for the following reasons. So that is to build in transparency and accountability in how the executive authority may exercise this discretion. This is acknowledging that it would be difficult for the ad hoc committee to now develop an exhaustive closed list of all the reasons under which it might be rational for the executive authority to exercise that discretion. See. I think the scrolling might take more time than the talking. Okay. The second issue was in the initial formulation of recommendations, there was quite a few definitions that required there to be a relationship of dependency between the primary resident and the persons living in the household with the resident. And members were saying that currently there are varied familial support configurations accommodated with the villages. Right? So you might have an elderly member who stays in the villages with her daughter, her adult daughter, or primary residents staying, who's the MP staying with their parents, for example. And so we are saying that the requirement for a relationship of dependency between the primary resident and the members of their household should not be a consideration in deciding who should lawfully reside in the villages. The limiting factor will, however, be the occupancy norm. So if I have a house, if I'm given a residential unit and the occupancy norm for that residential unit is 3 people, then that will be the limiting factor. Then only 3 members of my household may stay there with me because otherwise it's a safety and security, occupational health risk. So that will be the limiting factor. Look at that was just to clarify. Then what the policy review report does, it just clarifies this relationship between the board and DPWI in respect of how the funds are being used, but we've dealt with that in the presentation. The most substantive change to the policy review report is reflecting on the inputs of the workshop. Yeah? So just reflecting that the workshop was held on the 24th of April, who the invited persons or officers was. It reflects on the fact that the Minister of Transport, though not in attendance, in correspondence dated 20 April, did indicate his support for the recommendation that Parliament become the custodian of the parliamentary villages. We reflect on the fact that DPI was invited, but that neither the Minister or the DG or DPWI had been present at that engagements, but that the DPWI was in attendance when all of the decisions of the committee was taken. We had representation from the Joint Standing Committee on the Financial Management of Parliament, even though indicating that the Trace FMP had not yet deliberated on the recommendations. but the input pretty much focused on whether the budget will follow the function in respect of the custodian responsibilities of Kiama. The Office of the STP welcomed the legislative review process and that the villages are now being recognized as a strategic asset. Also from the same office, there was the committee was advised that there's also at the same time the consideration of the development of alternative housing provision. SAPS expressed agreement with the policy review recommendations, except for the recommendation that the registration of a criminal complaint be made mandatory, as in South African criminal law, you cannot compel a person to register a criminal complaint. Then, as part of the workshop, it was suggested that the ad hoc committee consider how the Department of International Relations and Cooperation has fared in its role as a custodian of South Africa's diplomatic properties abroad. There was a concern that the difficulties DIRCO has had as custodian has resulted in, amongst other, adverse audit findings. So we went back and did some research. So just a snapshot at the moment, members, but there's a difference between Parliament and DIRCO in the sense that DIRCO occupies a uniquely complex position as the custodian of South Africa's diplomatic properties abroad. Their custodial responsibilities extends across multiple jurisdictions, legal systems, cost environments, exchange rates, etc. So what DIRCO is required to be is to be a custodian for more than 150 movable properties abroad, including chanceries, official residence, and staff housing. So DIRCO's annual reports reflect on the challenges that it has had, including weaknesses in respect of asset register accuracy, maintenance planning, and capital projects execution, leading most recently to DIRCO receiving a qualified audit opinion in its 2024 annual financial statements. So like I said, we present a snapshot here, but it is recommended that Parliament, parallel to work of the ad hoc committee, engage with DIRCO on its experiences with a view of identifying risk mitigation measures for Parliament. So drawing on the DIRCO experiences, what are some of the pitfalls that Parliament should look out for? Then members also, subsequent to the workshop, as I've said, we were informed that City of Cape Town is the owner of the immovable property that Laboria Park is located on. So being unaware of that fact, City of Cape Town has not been approached as a key stakeholder in the committee process so far. What then happened is upon becoming aware of that, correspondence was sent to the City of Cape Town, providing the discussion document, and requesting input from the City of Cape Town on the recommendations that the committee has made, including the recommendation that the Executive Authority of Parliament be assigned the role of custodian. We also specifically asked the City of Cape Town, is there anything in the agreement in terms of which DPWI's use of the land that will limit the rights, that would limit the responsibilities of Parliament as a custodian in terms of Kiama? So the response was requested by 18th of May. At the time of this report, it has even not yet been received. But during the process of public consultation on the draft bill, City of Cape Town will again be given an opportunity to provide any inputs it would want to make. But that is just to ensure that the ad hoc committee has engaged with all significant stakeholders before taking its policy review, before finalizing its policy review report, as opposed to an afterthought. So this is a summary of the inputs by legal services. I would not have to repeat it again, but this is simply to just holistically then look at the governance and legal framework that would be applicable to villages. So this is what Ms. Hallie-Starkley has spoken about in terms of procurement decisions, the role of the SCP in relation to custodian, the role of the Joint Standing Committee Financial Management of Parliament, and the position regarding contracts with service providers. We have already thoroughly ventilated that. We've also spoken about the limitations on Parliament in its role of a custodian because it is not the landowner. So this is just the proposed formulation for the bill to give effect to the decision that the relationship of dependency must be removed. Again, a proposed formulation that says that the occupancy norm in the house will be the limiting factor for how many members of the household there might be. There's no longer requirement for dependency between the primary resident and the household. This is just affecting the decisions the committee has made about the Act mustn't stipulate a chairperson. The board will, from amongst its members, elect a chairperson. Then, during the workshop, the input from the Office of the FCP is that there is just one thing that we need to clarify in respect of the proportional allocation of housing units to the political parties, right? In the sense that when the housing units are allocated to political parties proportionally, there has to be some sort of limiting factor. Yeah? And that limiting factor is the number of seats that party holds in the National Assembly once the members of the National Executive has been excluded. So if a party has, even if 500 units are technically available, if a party's representation in the NA is 50, you take the National Executive members away, you are then sitting with 30 members. That will be the limiting factor for the amount of housing units that political party will get in the village. The same approach is used for the NCOP. The number of NCOP delegates, excluding the special delegates, would be like your premiers that have housing arrangements in terms of the benefits within provincial parliament. So that then provides a limiting factor. It frames the amount of units that would be available, might be available to political party. It cannot be more than the members that party has, in the National Assembly. Okay. This is just to say this is the regulations that the executive authority may, the matters on which the executive authority may issue regulations on. And here we're saying, look, we took the decision that the board is not going to report to the Joint Standing Committee on the Financial Management of Parliament. It will, it will resort under, it will report to the Executive Authority of Parliament. Just the addition of the transitional provisions, but again, this is the area that has already been covered by legal services. There's a consequential amendment that is necessary to GIAMA to include the Financial Management of Parliament and Provincial Legislatures Act, because currently the definition for accounting officer is a cross-reference to the PFMA, which does not apply to Parliament. And then this is just a summary of engagements that must take place so that it can feed into the public consultation on the draft bill. Parliament to engage with National Treasury on the date on which the Act is to come into operation so that it aligns with the budget. So you see in Acts, for example, that it will say that the Act is to come into effect on the 1st of April, or is to come into effect on the date of the commencement of the next financial year. That will just also be part of the transitional provisions. We're saying Department and DPWI must engage on an audit of existing contracts, the costing for the day-to-day operations and administration, so that Parliament can take that into consideration. Any limitations that may be imposed on Parliament because it's not the landowner, in Acacia Park and Pelican Park, and any other transitional provisions that will be necessary to give effect to the provisions of the bill. Parliament must also engage with the City of Cape Town on any limitations that be imposed on Parliament as a custodian in respect of Laboria Park. And then finally, that Parliament engage with DIRCO on its experiences in taking on the custodian role in respect of the property. Thank you very much, Chairperson.
Thank you very much, colleagues. It's helpful as engaged and as enhanced by our decision now. Maybe one of the things we might need to do just as an additional measure on our side is to probably try and get a sense of the value of the estate there where the land is owned by a city of Cape Town, vis-a-vis the value of the land itself. If that such information is available, so that we are able then to make a decision, because at some point we'll have to make a call either to purchase that land because we already have assets there over time, so that we don't have future problems like that. So I think this is one issue that you can give it to the researchers to try and find that information to us. At the conclusion of this whole process, we might need to probably, amongst the things that will be urgent for the incoming board or incoming, STP as an authority to look into as a side issue. Can we get the move and seconder for the report as amended with the new features that have just been made our decisions? Members? Member Mahafan, I see your hand is up. A member Aramulube.
Thank you, Chair. I move, Chair, with the amendments that are made.
Thank you very much.
I second, Chair, with the amendments.
Thank you very much, Member Litchfield, second with all the amendments. Thank you very much. The next presentation, we're left with few minutes. We've got other engagements, so we have to finish the meeting at least just before 11. The team, thank you very much. Report has been accepted with amendments. So we are enabling you to go to the next stage of the draft, and then maybe just before you start the new presentation, can you take us into confidence? How long will that take, and then what is the next step? Yes, technical team. Dr. Clark.
Yes, sorry, Chairperson. I'm speaking to Talana Halley-Starkey.
Yes.
Yes, Chair, we had said originally, I'm a bit thrown now because I know our timelines have moved a bit. Originally, we said it would be 4 weeks from the previous Friday. So now we're dealing with, we still require 4 weeks to draft. We cannot draft within 3 weeks. It will honestly be doing a disservice to the body of work that we've done so far. So 4 weeks from now would take us to, my colleagues are just calculating the dates for the next meeting. And that would be
at the end of June.
The 26th of June, where we will present the first draft of the bill. And then you would have to, we would then take the committee through the first draft of the bill, and we would then require another week to make amendments, if there are any amendments raised in that meeting, and then present the second draft of the bill, and then approve that second draft, and then proceed with advertisement.
Okay. Are we gonna need parliamentary decision once all the internal processes have been done at the ad hoc level?
Yes, you have to approve the bill, Chairperson, before. You have to approve the draft before we actually advertise. So the bill will look, so the first draft after 4 weeks. Sorry, I was muted there. So after 4 weeks, we will present a first draft of the bill.
Yes.
In that meeting, we'll take the committee line by line through the bill. Where the committee, through a resolution, feels that certain sections should be altered, or we proposes certain amendments, we will then take those decisions, and after a week, amend the bill and represent the second draft to the committee. After which, the committee will then approve the draft bill, and the bill will then be advertised which has a 4-week cycle for to advertise for comments. I hope I'm clear, Chairperson. So do you want me to repeat the process again? So we've got 4 weeks from now, which will take us to the 26th of June, where we present the first draft, followed by amendments made by the committee. Then legal service would then take those amendments and revise the bill, and then present the bill at the next meeting, which is will be the first week of July then, I think, the first week of July. And once the committee then approves that second draft, we will then advertise the bill. And the advertisement will go out, and we will receive public comments from that advertisement, which normally circulates for a 4-week period. And when we receive those public comments, we will then present those public comments to the committee, and both with myself, my colleague Daksha Kasan, and Dr. Clark will respond to those comments. And if there requires any other further amendments, following those comments, we will then redraft the bill, and you'll get a third version of the bill, and then introduce the bill. Was I clear, Chair? Sorry, am I audible, members?
You are yeah,
Sure.
you're audible.
Sure. Was I clear? I think it's the Chair's connection, right, Dr. Litchfield?
I think so too, because on both instances you were audible.
Okay, great. Is there anything that requires further clarity? Are we in agreement with the timelines, honorable members? Let me not presume here that I'm the chair. Is there anyone that can chair?
I am in agreement with the timelines. If I can just clarify quickly, when you present the bill to us line by line and something needs to be amended, you will take a week to amend and then you bring it in back as a second draft.
That is correct, Honorable Member Chabalala.
Then I'm in agreement.
Thank you. And then also remember, and I want to stress this, if when we advertise the bill for public participation, there could be comments that we receive from the public and from stakeholders that might influence the second draft that we presented to the committee. Then we have a third bite at the cherry, and we can amend the bill again according to whatever comments, if you are in
Are we
agreement
fine?
with the comments. Yes, Chair. I'm just, Honorable Chabalala asked a question, so I'm just clarifying.
Okay.
So
Are you satisfied, Member Shabalal? Sorry, I was muted. I couldn't hear.
Yes, I am, Chair. I did say I'm satisfied. She answered, but she's just elaborating on external inputs into the bill.
Okay. Thank you very much. If you are covered, I'm happy. So what's the next step? So we're done with this issue because we've made recommendations. Is there
yes,
another item? Yes. Is there another item for us?
Yes, Chairperson, there is
We have
two
to be
items.
very quick. What are
Yes,
those?
the first one. All right, Chair. The first one is the minutes of the subcommittee. Sorry, of the ad hoc. I'm going to start with the minutes of the 6th of March. Chair, these minutes have been deferred twice already. And can I request Hlupeka to make me a co-host so that I'm able to share quickly? As I was indicating, Chair, the minutes of the 6th, they have been twice deferred. So we're hoping that they will be adopted. I'm still waiting for, there it is, the minutes are being shared, Chair. If you can go down, that's the first page. Chairperson, it was the presentation, okay, on the agenda. Let's go back to the agenda. Scroll up to the agenda. Thank you. Yes, Chair, it was just the presentation by Public Works and Infrastructure on a 5-year historical budget, expenditure for all costs, the factors informing its determination, assessment of the composition and functioning of the board for the past 5 years, and the identification of the legislative and policy gaps. You can scroll down, and as Chairperson have indicated that the minutes can be considered as read, and members can indicate on areas where they would like us to. My sincere apologies.
Thank you very much. Can we get a move and seconder, colleagues, for the first set of minutes?
I move, Chair.
Thank you very much. Ramlevang moves.
I
The second.
second, Chair. I
Thank you.
second, Chair.
Thank you very much. The next minute.
If you can share the next minutes of the 20th of March, Hlupeka. Thank you. Thank you very much. Chair, those were the minutes of the 20th of March, where you received a briefing from CLSO on the rights and responsibility of users and the custodians in terms of CAIMA. The briefing by the Secretary to Parliament on the needs and priorities and the capacity. Sorry, Chair, and the capacity. And then if you can scroll down, Hlupeka. If you can just scroll down until the end of the page, as Chairperson had indicated, we've shared the minutes and we're taking them as being read. If members have any input, they can just indicate and then we can take care of that. Those are the minutes of the 20th of March. Thank you, Chair.
Thank you very much. Can we get a move and seconder?
I move, Chair. I was chairing this, so I move.
Thank you very much, the Chairperson.
I
Seconder.
I second, Chair.
Thank you very much. The next set of minutes.
Thank you, Chair. The next set of minutes will be a minute for the workshop, Chair. We drafted these minutes, Chair, so that the committee decision could be reflected as such. A number of very important decisions were taken during that workshop. If you can scroll down, Hlupeka.
Let's get a mover and seconder. Member Litchfield, I think you are not in this particular meeting, so other members who were there must assist us as well.
I move, Chair. Was in the meeting.
Thank you very much. Any seconder? Who's the other member who was there? If you can just go to the list, please. Can members assist us? We need to conclude.
Honorable Clark was in the meeting, Chair.
Yes, but I think she has left.
She left.
Oh, this one will be difficult. Honorable Mvana, I saw her on the platform. She was there.
Yes, Honorable Mvana. She's in another meeting. Can someone drop her a message maybe to help us second? And because I'm also rushing, I've got 4 more minutes here. And let me.
Or Chairperson, these ones we can defer them to the next meeting. I don't think we.
But do we have
should
other
just-
minutes, Chair? Chair, I will suggest if we have another set of minutes, we can then park this aside whilst I try to get hold of Honorable Mvana, because she is part of the meeting, just to be able to assist.
Yeah, please. Do we have another minutes?
It's the oversight report, Chair. So that will give us time. We'll try and run through it quickly because we also take it as read, Chairperson. Thank you.
Yes.
If you can share the oversight report.
Yes, let's proceed.
Hlupeka, if you can please share the oversight report.
Terence, I don't think you sent me the report.
Please give me hosting rights so that I can share it. Please give me co-host rights, Hlupeka.
Rights granted.
Please proceed.
My apologies, Chair. I hope, yeah, I didn't miss out. This is just the report, as I've indicated, of the committee to Pelican Park and Acacia Park.
Thank you very much. Can we just get the move and seconder because we were there, colleagues?
I move, Chair, for its adoption.
Thank you very much. Seconder? Member Ramulubeng?
I second, Chair.
I was not there, Chair, on the oversight. That's why I'm
Okay.
quiet.
Okay, who's there? Who's second? Mahafan?
Yes, it's me,
Chairperson,
Chair.
I
I
think the member.
I raised my hand so you don't notice, but
I didn't. Okay, you're second. Were you there at the workshop?
I was at the I was at the oversight. Isn't this for the work oversight?
Yeah, yes. I'm not. We're done with that one. We've agreed. I know you were there. I'm asking about the workshop. Were you there?
No. I was not present.
Okay, who was there at the workshop? Because we just need a seconder. The mover. We found the mover.
Which workshop is that, Chair? If they can come back and...
The 24th of April.
Oh, the one... No, I was there, Chair. I moved. We just need a second. And I'm struggling to get Mamfana.
I second, Chair, Honorable Makasi. I was there in the workshop.
Thank you very much. The minutes have been seconded. Can I then adjourn the meeting because we've got other engagement? Thank you very much, colleagues. And then please communicate with us on the group in terms of the next step. In terms of the next step, so that members know what to do. Thank you very much. The meeting is adjourned.
Thank you very much, Chair. Thank you, Chair.
Thank you, Chair.
Thank you, Chair.